In 2016, the Federal Defend Trade Secrets Act was passed. When it passed in 2016, it was considered one of the biggest developments in intellectual property law in a while, and it continues to be a huge factor in intellectual property rights today. I'm going to provide a brief overview of the DTSA and why you should be familiar with what it says. The first and maybe most significant thing that the Defend Trade Secrets Act says is that it gives trade secret owners a federal right of action. What that means is it gives people who own intellectual property the right to sue directly in federal court. This is a big deal because for the most part, prior to the DTSA being passed into law, intellectual property and trade secret disputes had to be brought in state court. The issue with that is that states vary in their intellectual property laws. So what might be protected as a trade secret in one state might not be in another state. And what constitutes misappropriation of a trade secret might not be illegal if you cross the straight line. By allowing trade secret owners a path directly into federal court, the DTSA simplifies the process for people who are victims of trade secret misappropriation. Now, the DTSA doesn't preempt state law, so while a trade secret owner now has the ability to go straight to federal court to pursue a misappropriation claim, that owner may decide that state court is actually a better option, and under the DTSA, that's totally fine. Trade secret owners just have more options now than they did before the DTSA. State court, federal court, or both, it's all on the table. The second big thing the DTSA does is clarify what things are protected as a trade secret and what kinds of actions constitute trade secret misappropriation. In light of what we just discussed regarding the confusion that has stemmed from different intellectual property laws in different states, this is a much needed addition to trade secret protections. Now, thanks to the DTSA, it's a lot easier to know ahead of time whether your intellectual property will be considered a protected trade secret when you get to court and whether the actions you're suing over will be considered misappropriation or not. And on top of clarifying, the definitions in the DTSA really broaden what intellectual property falls under the scope of a protected trade secret. The definition in the DTSA extends to a wide range of things, from written formulas to trade practices and much more. So in this way, the DTSA offers more protection to a wider array of trade secret owners because more kinds of intellectual property are considered protected trade secrets under the DTSA. The third big thing to come out of the DTSA is called ex parte seizure, which we'll call civil seizure here. Now, this is a new remedy available to you if you're a trade secret owner, which can get you almost immediate relief in the event that someone has misappropriated your trade secret. Previously, if you were a trade secret owner and your intellectual property was misappropriated, you had to bring a suit and then wait and see how the court saw the issue, and hopefully if you had a solid case and good counsel, you would win and then be able to enforce your rights. Well, the problem with that was that it could take months or even years to resolve itself, and in the meantime, your trade secrets were out there being used for who knows what. By the time the lawsuit was completed and you finally had the court order stating you could enforce your rights, oftentimes the damage was already done and you could have suffered an irreparable loss. This is where civil seizure comes in. What the DTSA says about civil seizure is that in the event a trade secret owner's intellectual property is misappropriated, the owner can petition the court to issue an order allowing the owner to go seize whatever property is necessary to prevent the trade secret from being used or disseminated, without waiting until the end of the trial. The benefits to the trade secret owner here are obvious. Let's say, for example, that an employee takes home a computer with a bunch of proprietary information on it, and the employer is afraid the employee is going to sell the information or give it to a competitor. Well, the owner can go to the court and petition for an order to seize the computer to make sure that nothing gets improperly used or disseminated. Of course, this kind of remedy is an extreme measure, and as such, the courts are going to require very good grounds for issuing any seizure orders. Trade secret owners will need to be able to show to the court that immediate and irreparable harm will occur if the order isn't granted, and they'll have to show that the person actually has the trade secret as well as a variety of other things. The court will also consider the potential harms of granting or denying the motions before granting the motion. This isn't the type of remedy that will be a regular occurrence in trade secret disputes, but for trade secret owners, it's good to know that it's an option in sensitive situations. And finally, the DTSA contains a whistleblower protection provision. This provision states that anyone who reveals a trade secret to a government official or an attorney for the purpose of exposing violations of the law is immune from civil or criminal prosecution. Additionally, the DTSA protects whistleblowers and employees by requiring employers to notify their employees about the whistleblower protections provided in the DTSA if those employers want the full protections of the DTSA. The DTSA provides employers with the option to pursue previous employees who violate trade secret laws for punitive damages and attorney's fees, but only if they've provided notice of the existence of the DTSA's whistleblower provision. In conclusion, the DTSA is a big piece of intellectual property legislation that has far-reaching effects. Chances are it has, does, or will affect almost everyone in business because its reach is so broad. At the end of the day, The main thrust of the DTSA is to provide trade secret owners with even more options and more protections when it comes to their intellectual property rights. As the DTSA demonstrates, intellectual property is a complicated field of law and can get confusing fast. Having effective legal counsel to cut through the fog for you and protect your rights can be a game changer. The attorneys at Denton Peterson have decades of experience dealing with all kinds of intellectual property matters. No matter the issue you're facing, we can make sure your trade secrets are secure. Feel free to contact us today if you have any questions about how to protect your intellectual property.